You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. California's Consumer Privacy Framework is anchored by the California Consumer Privacy Act, CCPA, of 2018, and its amendment, the California Privacy Rights Act, CPRA, of 2020. Together, these statutes form the most comprehensive state-level privacy regime in the United States, creating rights for residents and duties for organizations that process personal information. The scope is intentionally broad, reflecting California's recognition of its role as a regulatory trendsetter. The CCPA-CPRA framework establishes a baseline for consumer expectations around transparency, control, and accountability in the digital economy. Businesses operating in California, or targeting its residents, must treat personal information with greater care, aligning their practices with principles of fairness and trust. For learners, it is helpful to see California's laws as both protective and catalytic. They shield residents from overreach and set a model that other states have increasingly emulated in building their own privacy frameworks. Applicability thresholds define which organizations are covered by the law. The CCPA-CPRA applies to businesses that meet revenue thresholds, process data for a minimum number of residents, or derive a significant portion of their income from selling or sharing personal information. These criteria ensure that obligations fall on entities with meaningful impact rather than small operators. Importantly, joint ventures and consolidated entities are also within scope, preventing companies from structuring around the thresholds by dividing operations. For example, a retail chain with multiple subsidiaries cannot escape coverage by fragmenting its revenue streams. California law aggregates these operations to assess applicability. This approach demonstrates California's intent to regulate entities based on their real-world footprint rather than formal structures. For learners, thresholds underscore the principle of proportional accountability. The greater the scale, the stronger the obligations. The law carefully distinguishes between roles such as business, service provider, contractor, and third party. A business determines the purposes and means of processing personal information, while service providers and contractors process data on behalf of the business under contractual restrictions. Third parties, by contrast, operate independently and face limits on further selling or sharing personal data. These definitions clarify responsibilities and prevent loopholes. For example, an advertising network classified as a service provider must adhere to strict use restrictions, while as a third party, it would require opt-out opportunities before using data. This role-based system parallels international frameworks like the GDPR's controller-processor model, but adapts terminology to U.S. contexts. Learners should recognize how these distinctions drive compliance obligations. Understanding one's role is the first step in understanding one's duties. Personal information under CCPA-CPRA is defined broadly, encompassing any information that identifies, relates to, or could reasonably be linked with a consumer or household. Sensitive personal information is a new category introduced by the CPRA, including identifiers like social security numbers, precise geolocation, health data, racial or ethnic origin, and union membership. These categories matter because they trigger heightened rights and restrictions, such as limits on use and sharing. For example, while browsing history may be treated as general personal information, precise GPS coordinates fall into the sensitive category, requiring additional opt-out options. By carving out sensitive categories, California acknowledges that not all data carries equal risks. Learners should understand that classification is not just theoretical. It shapes the obligations businesses face in protecting different types of consumer information. The consumer definition under CCPA-CPRA is expansive. It includes not only individual residents but also those acting in a household context, meaning data collected from shared devices or accounts may be protected. Initially, employee and business-to-business data were temporarily exempt, but amendments under the CPRA have brought these categories closer to full coverage. For example, an employee's personnel file and a contractor's account details are now treated as personal information under the statutory scheme. By extending protection beyond consumer-only contexts, California emphasizes that privacy rights are not limited to commercial transactions. Learners should recognize this inclusivity as an evolution. Privacy protections extend to the workplace and professional settings, reflecting the pervasive role of personal data across life domains. Core consumer rights form the centerpiece of the CCPA-CPRA framework. Residents are entitled to access their personal information, request its deletion, correct inaccuracies, and receive copies in a portable format. These rights empower individuals to engage directly with businesses that hold their data, reshaping the traditional imbalance of power. For instance, a consumer can request a copy of their profile from a retailer, identify outdated contact information, and demand corrections. Portability rights allow individuals to take their data elsewhere, fostering competition by reducing lock-in. For learners, these rights represent a shift from passive notice and choice models to active participation. Consumers are no longer simply informed about practices, but are able to shape them through direct action. Opt-out rights address the selling and sharing of personal information, ensuring residents can limit how their data flows across contexts. Selling is broadly defined to include exchanges for monetary or other valuable consideration, while sharing extends to data used for cross-context behavioral advertising. Consumers can exercise their rights through visible mechanisms such as "do not sell or share my information" links, which businesses must honor. Imagine a streaming service sharing viewing habits with advertisers for targeted ads. A user can opt out, and the service must stop those practices. This right curtails the uncontrolled spread of data and reasserts consumer choice. For learners, opt-outs highlight California's pragmatic approach, allowing data-driven practices but giving individuals the power to say no. Targeted advertising, particularly cross-context behavioral advertising, is tightly regulated under CPRA. While contextual advertising based on the content a user is viewing is permitted, advertising based on profiles built across different websites or apps is subject to opt-out rights. For example, if browsing for hiking gear on one site leads to shoe ads on another, that practice is regulated sharing. These rules address consumer concerns about surveillance and invisible data flows, limiting profiling that feels intrusive. At the same time, California preserves room for contextual advertising, which aligns more intuitively with user expectations. For learners, this distinction illustrates how law balances business interests and privacy. It permits relevant ads while curbing practices that cross into surveillance territory. Sensitive personal information introduces further restrictions under CPRA. Consumers can direct businesses to limit the use of sensitive data to what is necessary for providing requested services. This means businesses cannot freely use sensitive identifiers for unrelated purposes like marketing or profiling without explicit controls. For example, an app collecting precise location data to provide directions cannot repurpose that data for targeted ads without offering an opt-out. This new layer of consumer control reflects recognition that sensitive categories warrant heightened safeguards. For learners, the key insight is that sensitivity is not symbolic. It carries concrete compliance duties that elevate protections for data most likely to cause harm if misused. Purpose limitation and data minimization are new requirements under CPRA that align California law more closely with global frameworks. Businesses must collect only the personal information necessary for specified purposes and use it only for those purposes. For example, a retailer that collects email addresses for receipts cannot repurpose them indefinitely for marketing without additional notice. This principle forces organizations to justify data collection and curtail overreach. Learners should understand minimization as a common-sense guardrail. It is like carrying only the tools you need for a task instead of weighing yourself down with unnecessary baggage. By limiting collection to what is relevant and purposeful, Businesses reduce both compliance risks and exposure to breaches. Retention schedules are another compliance anchor under CPRA. Businesses must not only establish limits for how long personal information will be kept, but also disclose these retention periods by category in their privacy policies. For example, a business may state that purchase history is retained for 7 years for accounting purposes, while customer service chat logs are deleted after 18 months. This obligation aligns retention with transparency, ensuring individuals are aware of how long their data lives in organizational systems. Learners should see retention schedules as both compliance and trust-building measures. They communicate discipline in managing data life cycles and reduce the risks associated with indefinite storage. Notice at collection remains a critical transparency tool. Businesses must inform consumers at or before the point of data collection about the categories of information collected, purposes for use, and consumer rights. This may appear as banners on websites, in-app disclosures, or layered notices that provide both summaries and detailed explanations. Privacy policies must also be updated to reflect these disclosures, creating consistency across channels. For example, an e-commerce site prompting for an email address at checkout must disclose whether that information will also be used for marketing. Learners should recognize that notice is not static. It must evolve with practices, ensuring consumers are never caught unaware about how their information will be processed. Global Privacy Control Signals, or GPC, are explicitly recognized under CPRA as valid opt-out mechanisms. This means businesses must configure their systems to automatically honor browser-level signals expressing consumer preferences not to sell or share data. Crucially, the law prohibits friction in honoring these signals. Businesses cannot require users to log in or take additional steps once a valid signal is received. For example, if a user activates GPC in their browser, an advertising network must stop cross-context tracking without further action from the individual. This recognition marks a move toward universal, user-friendly control of privacy preferences. For learners, GPC underscores the evolution from manual opt-outs to seamless, technology-enabled enforcement of consumer choices. Dark pattern prohibitions extend to consent and choice architecture under CPRA. Businesses cannot design interfaces that manipulate users into agreeing to data practices, such as making opt-out buttons obscure or requiring multiple steps to exercise rights. Interfaces must present options neutrally, allowing individuals to make free, informed choices. For example, if an app presents a bright green button to accept all and hides the decline option in small gray text, it would likely violate CPRA's standards. These prohibitions reflect a growing recognition that design influences behavior and that fairness in privacy requires equal visibility for all options. Learners should understand dark patterns as not merely unethical, but now explicitly unlawful under California's framework. Children's privacy receives special attention under CPRA, with stricter rules for minors under 16 and additional parental consent requirements for those under 13. Businesses must obtain verifiable parental consent before collecting or sharing information from younger children, and must provide opt-in mechanisms for teens. For example, a social media platform targeting California users must design its onboarding process to verify parental approval for 12-year-olds and provide opt-in controls for 15-year-olds. These protections reflect California's commitment to shielding vulnerable populations from overreach and exploitation. For learners, children's privacy illustrates the principle that the younger the consumer, the higher the duty of care, both in obtaining consent and in limiting data practices. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Contracting requirements are central to CPRA's compliance framework, especially for businesses working with service providers and contractors. Agreements must include flow-down terms that restrict these partners from using personal information for their own purposes, require security measures, and mandate deletion at the end of the relationship. For example, if a retailer hires a contractor to process online orders, the contract must prohibit that contractor from reusing customer data for unrelated marketing. These provisions transform contracts into privacy controls, ensuring that obligations follow personal information wherever it travels. Learners should view this as a safeguard against shadow practices. By embedding compliance into contracts, businesses extend their accountability beyond their own walls, creating a chain of responsibility that regulators and consumers can trace. Third parties are treated differently under CPRA, with their obligations focused on limiting further selling or sharing of data. Once information has been shared with a third party, that party cannot simply repackage or redistribute it without honoring consumer opt-outs and other restrictions. Imagine an advertising network receiving browsing history from a clothing store. It cannot then sell that information to additional brokers unless it complies with California's rules. This approach closes potential loopholes by ensuring that rights follow the data, not just the first business that collected it. Learners should recognize this as a shift from entity-based compliance to data-based accountability, making sure protections persist across the ecosystem. Data protection assessments are triggered under CPRA when businesses engage in high-risk processing activities. These assessments require documentation of the processing purpose, risks to individuals, and mitigation measures. High-risk activities may include extensive profiling, processing sensitive personal information, or large-scale data sharing. For instance, a streaming service using algorithms to create behavioral profiles for advertising must conduct an assessment to evaluate potential bias or harm. This obligation parallels global practices like GDPR's data protection impact assessments, showing how California is aligning with international standards. Learners should see assessments as more than paperwork. They are opportunities for organizations to pause, evaluate, and justify their data practices before risks become liabilities. Automated decision-making is another area where CPRA provides rulemaking direction. Although the law leaves details to future regulations, it signals that consumers may gain rights to understand, contest, or limit the impact of automated decisions in significant areas like employment, housing, or credit. This aligns with growing global concerns about algorithmic bias and transparency. For example, if a consumer is denied a loan based on a credit scoring algorithm, California may require businesses to explain the decision and offer review mechanisms. Learners should note that while CPRA's provisions are still evolving, they point toward a governance model where fairness and explainability become mandatory features of automated systems, not optional add-ons. Employee and business-to-business data, once subject to temporary exemptions, are increasingly folded into the CPRA's coverage. This means employers must now provide employees with rights such as access, correction, and deletion for personal data held in HR systems. Similarly, information collected about business partners and vendors may also fall under the law's protections. For example, a consultant's contact information and project notes maintained by a company could be subject to consumer rights requests. This expansion demonstrates California's acknowledgement that privacy concerns do not vanish in professional settings. Learners should understand this as a major evolution. Privacy law is not only about consumer transactions, but about personal data in any context, including workplaces and supply chains. Security program expectations under CPRA require businesses to implement reasonable safeguards for protecting personal information. While the law does not prescribe exact controls, it expects organizations to align protections with the sensitivity of the data and the scale of processing. For example, a financial institution handling sensitive identifiers must implement encryption, access management, and regular penetration testing, while a smaller retailer may focus on access controls and secure deletion. What matters is the ability to demonstrate that security measures are proportional and effective. Learners should recognize this as a recurring theme: flexibility paired with accountability. Businesses are free to tailor safeguards, but they must be prepared to justify them to regulators in terms of reasonableness and adequacy. Record-keeping, training, and audit readiness are critical operational elements under CPRA. Businesses must document their handling of consumer rights requests, maintain logs of privacy notices, and ensure staff are trained on compliance responsibilities. Audit readiness means being able to produce this documentation quickly during investigations or litigation. For example, if regulators question whether opt-out requests were honored, a company must provide consent logs and records of system updates reflecting the changes. Training ensures employees at all levels, from call center staff to IT administrators, understand their roles in protecting personal information. For learners, these operational requirements underscore that compliance is not just legal language but daily practice, reinforced by records and education. Dispute resolution under CPRA balances enforcement between regulators and private actions. Consumers have limited private rights of action, primarily related to data breaches involving certain types of information, such as social security numbers or financial data. Statutory damages can apply when reasonable security measures were not in place. Broader enforcement, however, rests with the California Attorney General and the California Privacy Protection Agency. For example, a consumer may sue after a breach exposing their bank account details but cannot sue over general opt-out rights violations. Learners should see this dual model as California's attempt to protect consumers while avoiding a flood of litigation private suits for security failures, regulatory enforcement for broader compliance. The California Privacy Protection Agency, CPPA, holds unique authority for rulemaking and enforcement, making it the first dedicated privacy regulator in the United States. The agency is empowered to issue detailed regulations, conduct audits, and enforce compliance independently of the Attorney General. For example, it can investigate whether a business's consent banners comply with dark pattern prohibitions and issue corrective orders. This dedicated oversight reflects California's seriousness about privacy and provides a model other states may follow. Learners should recognize the CPPA as a milestone. Privacy has moved from being one concern among many for general regulators to being the mission of a specialized enforcement body with broad powers. The Attorney General still plays an important role, coordinating with the CPPA on enforcement and pursuing litigation where necessary. For example, the Attorney General may sue a company for widespread violations of opt-out obligations, while the CPPA focuses on audits and corrective actions. This dual structure ensures both breadth and depth of enforcement, leveraging the litigation expertise of the Attorney General and the technical focus of the CPPA. Learners should see this as a complementary system rather than duplication, reinforcing that privacy in California is backed by multiple layers of accountability. Cure periods and penalties have evolved under CPRA. Originally, businesses were given a grace period to correct violations after being notified, but this provision has been narrowed. Now, cure periods are less automatic, and penalties may be imposed even for first-time violations if they are serious or intentional. Penalties can reach $2, $500 per violation, and $7, $500 for intentional violations or those involving children's data. For example, if a business knowingly ignores global privacy control signals, it could face enhanced fines. Learners should understand that this evolution reflects California's intent to strengthen deterrence. Compliance is not optional, and violations carry real financial consequences. The CPRA interacts with federal sectoral laws, carving out exemptions where overlapping regimes already exist. For example, data covered by HIPAA, the Fair Credit Reporting Act, or the Graham-Leach-Bliley Act may be exempt from certain CPRA provisions. These exemptions prevent duplicative regulation, but also require businesses to navigate complex boundaries. For instance, a hospital may treat medical records under HIPAA, while marketing data about patients could still fall under CPRA. Learners should see this interplay as a reminder that privacy compliance often requires layered analysis. One law may not fully displace another, and organizations must map obligations carefully across frameworks. Multi-state harmonization is a practical strategy for organizations facing a patchwork of U.S. privacy laws. Because California's CPRA is the most detailed and demanding, many companies adopt it as their baseline compliance model. By aligning with California's requirements, such as honoring opt-out signals, publishing retention schedules, and maintaining strict vendor contracts, businesses often meet or exceed obligations in other states. For example, a national retailer may apply California-level protections to all U.S. consumers rather than managing different regimes for each state. For learners, this illustrates the ripple effect of California's leadership. One state law effectively raises the compliance floor nationwide. Finally, program governance ties everything together by integrating policy, technology, and vendor ecosystems. Businesses must align their internal policies with technical controls, such as tag managers and preference centers, while ensuring vendors meet contractual obligations. Governance committees often oversee these efforts, coordinating across legal, IT, marketing, and compliance teams. For example, when a company introduces a new loyalty program, governance must ensure that the data collected aligns with stated purposes, retention schedules, and opt-out controls. For learners, this demonstrates that privacy under CPRA is not a siloed task, but a comprehensive program. Policy promises must match technical enforcement, vendor practices, and consumer-facing disclosures to create a defensible and trustworthy compliance posture. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.